All rise. The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished and say to draw nigh and give their attention to the court. Now sitting. Please be seated.
Good morning. Welcome to the Kansas Supreme Court. I don't think we have anyone in our physical audience this morning that's unfamiliar with the court processes, but I do know that we likely have people online, some of whom may not be. So I would like to take just a minute to kind of explain the processes for those who are online. We have at our last docket, it seemed like every day we had students in the courtroom. But I think with graduation happening over the weekend and that season. So for those who are listening, all justices are familiar with the facts of the cases and the parties' arguments. We have read briefs, we have read portions of records or all of records. We've read some of the authorities cited to us by the attorneys and otherwise prepared for this morning's argument. We now look forward to hearing the parties' oral arguments, and we will have an active exchange with the attorneys about their briefing and things that they may say today. I will also explain to you that we may at times take notes. Some of us will do that on paper. Some of us have computers. We are doing that to consult our notes or to check something in a brief, perhaps check a case or a statute, look at the record, or just even actually make notes for ourselves. We do this all to understand, to assist our understanding of the arguments as well as help us to process them. But we want to assure you that when we are focused on that screen, we are still listening. I will now ask Mr. Doug Shima, the clerk of the Kansas Appellate Courts, to please call the 9 a.m. docket.
The first case on the 9 a.m. docket for Monday, May 15th, 2023 is appeal number 124329, State of Kansas versus Philip Jason Garrett, Saline County, briefs both sides.
Please the court. My name is Justin Bravi. I'm the Salina Regional Public Defender, and I'm appearing on behalf of Philip Garrett. I'm present and ready for argument.
Okay, please the court, Chris Elslinger, Deputy Solicitor General, appearing on behalf of the state, present and ready for argument.
Second case is appeal number 125552 in the matter of the wrongful conviction of Damian Baumgartner, Sumner County, briefs both sides.
May it please the court, Larry Michaels, Salina, Kansas, on behalf of Damian Baumgartner, present and ready for argument.
May it please the court, Curtis Wired, Assistant Solicitor General, appearing on behalf of the state of Kansas, present, ready for argument.
Your Honor, that concludes our 9 a.m. docket.
I will now call forward the counsel on 124329, State of Kansas versus Philip Jason Garrett.
May it please the court. My name is Justin Bravi. I am the Salina Regional Public Defender, appearing on behalf of Philip Garrett. Chief Justice, I request 3 minutes rebuttal time at this time, please. Justices, this case is before you on our petition for review from the Court of Appeals decision reversing the district court's suppression of Mr. Garrett's statements to law enforcement in November of 2018. As a result of those statements to law enforcement, Mr. Garrett was charged with a number of sex offenses, which were alleged to have occurred between 2016 to 2018. In November of 2018, Mr. Garrett's 12-year-old stepdaughter alleged to this line of police detectives that Mr. Garrett had sexually assaulted her. Not long after this disclosure to the police detectives, Mr. Garrett was interrogated by 3 detectives of the Salina Police Department, Detective Jones, Detective Brown, and Sergeant Cox. Sergeant Cox utilized a program called a computer voice stress analyzer analysis exam, in which the law enforcement used egregious forms of deception in their police tactics.
Do you think it was deception, or do you think they actually believed it was 100% accurate?
Justice, I don't believe in this instance that it matters whether they believed it was 100% accurate or not. The fact of the matter is that the detectives in this matter, to a scientific degree, essentially is what they were arguing, that there was 100% effective and accurate. And it was deceptive, because that simply wasn't the case, as the motion to suppress and the subsequent hearings bore out.
Well,
Go ahead.
if I understand the evidence, though, let's see, it was Detective Cox or Investigator Cox that conducted the test. And then, as a part of their protocol, before they go back in to talk to the defendant, she shows the test results to another person trained as she is in reading this analysis, and he confirmed her view of the results. That seems to give some credence to them going in and discussing the results with him later, right? I mean, I'm not missing any part of the facts here. She did show it to somebody else in a cold setting. He didn't, that person didn't know anything about what was going on. They just saw the results and said, yeah, you're reading it correctly.
Justice, I don't recall that part of the hearing, but I'd be happy to brief that issue in particular, if the court would so desire. What I can tell the court is that the important issue before this court to consider is that the district court made specific findings of fact, that there was a combination of factors that the Court of Appeals disregarded and not following this court's set precedent. As this court is very familiar from State v. Talkington, and in this matter, the appellate courts, it's their duty to give the district court significant deference for their findings of fact and conclusions of law, and not to reweigh evidence, to assess credibility, or to replace essentially the district court findings.
But what are we looking for? I mean, I guess I'm trying to take off the table deception. And I'm doing that because the U.S. Supreme Court has told us to. I mean, detectives who come in and tell a person who's being interviewed that we found your fingerprints, on the murder weapon, when that was not true, that doesn't violate a constitutional provision. It's not like trying to search without a search warrant or something. So what is it we're looking for? Aren't we looking for evidence that the defendant confessed to a crime that he didn't commit?
What this court is looking for, and to answer your question, Justice, in this matter, what courts around the country have found is that there is not a per se approval for law enforcement officers to lie to suspects in a case. It's one part of the calculus that has to be considered. It is not the entire calculus. And so it's not something that this court can certainly disregard. This court can definitely look at the facts of the case and determine as one part of the totality of the circumstances. Because in this case, the ultimate inquiry and the voluntariness of the statements is whether the statements were voluntary under the factors that this court has laid out.
So what are those factors, I guess? So if we're looking to see whether the statement was voluntary,
And Justice,
What are those?
the factors that this court has to look at is the defendant's mental condition.
No. I want to know the facts in this. I understand. I know what the standard of review is on this thing. I want to know what facts the district court found that lead us to a conclusion that the statement was involuntary.
The district court looked at this as under the totality of the circumstances on a collective basis, not in isolation. So the factors that the district court relied upon was, number one, that the law enforcement minimized the Miranda warnings. Detective Jones, when he first came into or maybe not right at first, but very quickly, he minimized the Miranda warnings in this matter. Two was that the district court found that Mr. Garrett's mental state due to stress, lack of sleep, lack of food, were a factor that the district court relied upon to make a finding that it's not voluntary. The district court relied upon the deception that the law enforcement made repeated false claims that the computer voice stress analyzer was 100% effective and 100% accurate, and that they made implied promises of leniency for cooperation and perhaps threats as well. So the issue that the Court of Appeals missed in this matter was that they looked at each one of those individual factors under the voluntariness of the statements and in isolation. And what they should have done, and what this court has held, is they should have looked at it collectively. Because any single one of those things that the law enforcement officers did may just in and of itself may be okay. The problem here is that they did all of them. That's the problem in this particular matter.
For example, what difference does it make about the minimizing of the Miranda warnings at the beginning of the interview, which was not a particularly long interview, when Investigator Cox gave a very stern Miranda warning, told the defendant exactly why he was there and what they were looking for. And he even signed the release waiver before taking this test. So why do we look at the initial Miranda warning when they're in this media room where he's trying to explain, you're not in an interrogation room, you're in an anteway off a locked door? That doesn't seem to me to be all that bad, but what difference does it make when before he gives his confession, gets this very stern warning? I mean, you can't give a Miranda warning any more forcefully and in any better context than what she did with him.
Justice, what I think this court has to also be cognizant of is not to fall into the same trap that the Court of Appeals did, and substituting this court's findings of fact for those of the district court. What the district court found was that the law enforcement officers minimized the Miranda warnings, and there is case law, which I'd be happy to brief further for this court, which basically states that any minimizing of Miranda is simply not okay, and that's not that violates precedent. So, and on top of that, when Mr. Garrett goes back with Sergeant Cox to complete this false test, he is also confused. He doesn't understand what the word coercion means, and the district court found those facts to be important in this particular matter, and they relied upon and the district court Judge Johnson relied upon that in making his findings of fact. And as I understand case law at this time, it's the duty of the appellate courts to make inferences and find facts that support the district court's findings, not to replace them. And if this court reviews the Court of Appeals opinion in this matter, the Court of Appeals replaced the district court's findings of fact. In particular, with the Court of Appeals, they replaced a finding of fact for Mr. Garrett regarding his mental condition. The district court found that Mr. Garrett's mental condition was stressed and that he was hyped. He didn't understand the word coercion. But in the Court of Appeals opinion, what the Court of Appeals states is that Mr. Garrett's mental condition was stable and he was not subject to undue stress. That is a finding of fact that they replaced in this. And if the court looks at State v. Talkington, that violates this court's holdings.
Can you, let's get back to the deceptive practice, which we've held and US Supreme Court has held that some amount of deceptive practice, deceptive representation is okay. And here you're suggesting that the accuracy, the whole characterization of the computer voice stress analyzer was not accurate. It was deceptive. Why is that? How is it different than other deceptive practices that we permit?
On its own, it may not be different than other deceptive practices. The problem in this case is that in my argument for Mr. Garrett is that this court has to look at the collective issues that the district court found in this case. It wasn't just one thing. And that's what the Court of Appeals did, is they looked at each one of these individual items in isolation, not collectively. And so again, law enforcement can use some deception, but they do so at their own risk. And that's what happened here. They utilized a multitude of deceptive practices, which overbore Mr. Garrett's free and independent will.
Let me ask you a question. The minimizing the Miranda, is what else besides jump through hoops was there?
And Chief Justice, I see that I'm out of time. May I have leave to answer this question?
Yes, you may.
Other than minimizing Miranda in this case, the district court found that that Mr. Garrett was under a great deal of stress.
No, I understand what you're talking about with the totality of the circumstances, but on this one, minimizing the Miranda. He said at the beginning, got to jump through some hoops. And then he went through it piece by piece, and then he gave it to him to sign. So what else was there that minimized the Miranda warning besides him introducing it as jumping through some hoops?
I understand it, Justice, that it was also a delay in this matter of providing those Miranda warnings and not being upfront with Mr. Garrett about the purpose of the interrogation at the beginning. And
Really? I mean, I watched the video. He seemed to know why he was there from the get-go.
And more importantly, that's what the district court also found, is that it was that delay in giving those.
How much of a delay was it? They didn't start, maybe I didn't. I mean, I watched the video. What was the delay? How long was it?
I don't have that information
Okay.
off the top of my head, Justice.
Are you speaking of the delay to the Sergeant Cox's Miranda? Because that might have been some time, but I'm having trouble with the delay also. It seemed to be pretty quickly after they began discussing why he was there at that whole interaction.
Justice, I'm referring to the findings of the district court, in which the district court found that it was a delay in giving the initial Miranda in this matter.
And then with regard to the mental state, did the district court judge make those findings about the mental state based on the video? Because the defendant in this case, did he testify or no?
He did not testify, Justice. So
Because that's video, do we have to defer? If there's not substantial competent evidence to support, I guess that's not the exact standard, but in looking at it, he didn't, like, to me, he didn't look sleep deprived. Even though he said he was anxious, he didn't really look anxious. So are we required to give deference to the district court when we're looking at the same video the district court looked at?
yes. According to this court's holdings, the appellate court is supposed to give inferences and facts to support the trial court's findings. And pursuant to State v. Talkington, the appellate courts are not supposed to reweigh or assess the credibility or resolve conflicts of evidence. And what the Court of Appeals has done, what this court has to be careful of, is to not replace its own findings of fact for watching the
Counsel,
video.
would you agree that an appellate court finding of no substantial competent evidence is not the same as reweighing the facts?
In this particular case, Justice, there was the majority of the panel that did not believe there was a substantial competent evidence.
And that's not reweighing the evidence, is it? I mean, that's an appropriate, it might be wrong, and you can argue that it's wrong, but with respect to the standard of review, that's an appropriate appellate court action or finding, if you will. I mean, that's what appellate courts are supposed to do. Would you agree with that? I mean, you might not agree with the conclusion, but do you agree with the steps that they walked through?
Justice, I do believe it's appropriate because due to the dual standard review of reviewing a motion to suppress, what an appellate court is supposed to do is to review for substantial competent evidence. So that I do agree with.
And my reading of the Court of Appeals majority is that that's what they did. And they concluded, and they say this explicitly, that the district court's ruling was not grounded in substantial competent evidence. That's the last paragraph of their opinion.
But they base all of the last paragraph of their opinion on the replacement of the district court's findings for their own. And that's where the problem lies.
Let's
Justice.
take this sentence and see where we are with it. Went from the where the Court of Appeals talked about his credibility really and what his nervousness and stress told us. And they said that the nervousness and stress was nothing more than, quote, a thinly veiled attempt to offer an innocent explanation for any stress registered by the test. So just dissect that and look at, does that, are they saying that there is no support for the district court's finding? Or how do you think they are making a different finding of fact or reweighing of what the inference is from any nervousness or stress that's shown?
Judge Johnson in this matter made a credibility finding based on his review of the evidence and found that Mr. Garrett's stress and anxiety, the lack of sleep, the lack of food, all played into his involuntary statements in this case. And when the Court of Appeals made that finding that nervousness, stress was nothing more than a thinly veiled attempt to offer an innocent explanation for any stress registered by the test, that was replacing the district court's findings of fact that Mr. Garrett's statements were the result of that stress. That in and of itself violates State v. Talkington, this court's holding, and the duties of what the appellate court is supposed to do.
What about, I understand your argument with the majority opinion, but Judge Hurst's concurrence does apply maybe what looks to be a more traditional substantial competent evidence, or at least arguably, and still reaches the same conclusion as the majority. What's your argument in response to the concurrence, the analysis of the concurring opinion?
Justice, in this matter, I do agree that Judge Hurst agreed that there was substantial competent evidence for the finding, but then the Judge Hurst veered off course. And also if the court reads that concurring opinion, that Judge Hurst also basically they watched the video, or the judge watched the video and then made findings of fact replacing the district court's findings. And so that violated that. And on top of it, both, I believe, the majority and the concurrence missed the fact that that under the totality of the circumstances, which is the ultimate inquiry for the voluntariness of the statement in this case, they both looked at it in isolation rather than collective. Because as I had argued previously to the court, any one of those individual things may be okay, but taking in the collective under the totality of the circumstances, which is what happened here and what the district court Judge Johnson found, it makes the erroneous finding of the Court of Appeals in this case and reversing the district court.
Just on the last factor that you talked about, the implied promises of leniency, because there were no explicit promises of leniency. In my notes, looking at the video, they say, I would think you would want to continue cooperating, or that you would want to cooperate. And we'd like to go to the prosecutor and tell the prosecutor that you owned up and you were cooperative and even remorseful. Is there anything beyond those statements that that you believe anyway the district court relied on for leniency? And I guess my ultimate question is, how is that an implied promise of leniency?
Justice, there is case law that I cited in Mr. Garrett's supplemental brief that specifically addresses that issue. The matter in this case, to answer your question specifically, is that it wasn't just one detective also. It was also 3 detectives that were there. And then on top of that, we have Mr. Brown and, or I'm sorry, Detective Brown. And then basically, as this court said, he said numerous times, and in fact, between Detective Brown and Detective Jones, they said at least 4 times that they wanted to go tell the prosecutor that Mr. Garrett was acting in a cooperative manner.
But
The implied issue there, Justice, is that if he didn't cooperate, if he didn't confess right after he's being told that this test is 100% accurate and effective, truth verifying test, that if he didn't do that, then on top of the fact that he was told that potentially he was a monster within the community, taking all those things into consideration.
there's no evidence that they said he was a monster in the community.
There it is that Detective Brown said, we don't want you to be viewed as a monster in the community.
Okay. Okay. Just one other thing. So in State v. Johnson from 1993 and State v. Garcia from 2013, both are cases, a promise to tell the prosecutor that the defendant is cooperating is not coercive. It can only be that if it is would likely cause the accused to make a false statement to obtain the benefit of the promise offered.
And in this case, Justice, Mr. Garrett hasn't made the argument that there was an explicit promise for a benefit, but that there was numerous occasions that in this particular matter, the detectives told him that if he was cooperative, that they were going to go to the prosecutor and tell him he was remorseful, that he loved this young girl. And it wasn't explicit in this matter, but it was implied. And Mr. Garrett's argument in this case is that it was a collective issue. It's not just one issue. And that's
So
part
are you
of that
asking
analysis.
us to find as a matter of law, State v. Johnson and State v. Garcia to overturn those decisions and find as a matter of law that a promise to tell the prosecutor that defendant cooperated is coercive?
What I'm asking this court to find is that based on the totality of the circumstances, that, and while that may not be a per se violation of the rule in this particular case, that is a violation in this particular case based on the totality of the circumstances.
Chief, may I ask one question? Counsel, was there anything the district court considered, such as other evidence, arguments of counsel, besides just the raw video?
There was testimony from the law enforcement officers in this case as well as a defense expert that the prior attorney put on in this matter, and that testified that there was a Department of Justice study that showed that the computer voice stress analysis was at best 15 to 50% accurate. So the district court would have relied upon that as well. But what I would refer this court back to is Judge Johnson's findings that he made on the record from the July 30th, 2021 hearing, in which he specifically laid out the findings of fact and conclusions of law that he made.
Other questions? Thank you.
Thank you, Justice.
May it please the court, Chris Slager appearing on behalf of the state. Ultimately, when you look at this case, nothing that the police did here was so inherently coercive as to render the defendant's confession involuntary.
Given
And-
that when we have these issues come in front of us, the state's the one that has the burden of proof, right? You have to demonstrate that the statement was voluntary,
Yes.
right? So why is it so important that police officers use subterfuge in order to do their interviews with criminal suspects? It just makes your job that much harder, right?
It does. I can, in some instances, in some, every case, every interrogation is different. Many interrogations go by where there's no subterfuge used at all. In this case, I'm not sure there was subterfuge so much. I kind of got the impression that the police really believed that the CBSA was 100% effective, but
No one asked that question, which I thought was so weird in the evidentiary hearing, that the defense didn't just ask the detectives whether that was false, that 100%, that representation of 100%. Because the only person who said anything about that was the defense expert.
And ultimately, if you look at the case law, it really doesn't matter because as you've pointed out already, the US Supreme Court and courts across this country, this court have said police can use deception. So, at least one case I cited, they hooked the guy up to a box that just did nothing and said, this is a lie detector test. And then they told him he failed it. Well, if that's allowable, well, then telling a guy, using an actual.
Oh, go ahead.
Maybe I'm trying to think of the internet meme about saying something out loud. I'll say the truth out loud here, which isn't the reason they use it is because it's effective at getting defendants to say the truth.
Well, I think they believe it's effective to detect when they're being deceptive or
Well,
not. Just
no,
like a
it's
polygraph.
effective because when a defendant, a hypothetical defendant, is confronted with what the police deceptively claiming to know the truth, then in a defendant's mind, the defendant may think, well, they already know.
Right.
So I may as well just cop to it.
Yes,
may as
I would
well
agree
just
with
tell
that.
the truth.
I would agree with that in the case of the guilty defendant. He knows what he did.
Okay, but that's my
Yeah.
follow-up question, which is if it's an effective practice at obtaining the truth from a defendant, is the reverse also true? In other words, can these deceptive practices ever be effective at coercing a false confession?
Well, I don't believe so. I think the idea of a false confession, I could understand if somebody's getting their fingernails pulled out, confessing to stop the pain, right? That kind of torture. But this kind of stuff here, I cannot comprehend why
So in other
anybody would
words,
falsely confess.
Having these lies told to you, it makes sense that defendants being lied to in this way might just decide, oh, I may as well just tell the truth.
Well,
But it doesn't make sense that they would say, well, I may as well just admit that I raped a 12-year-old because I'm being lied to about this.
well, I think an innocent person would say, well, your machine is not 100% correct. You're wrong. I didn't.
I guess
he-
that's the gist of my question. So
Well, he tried to do that. I
He
think.
did.
He tried to do that. Well, I have a host of questions here. Tell me, just start this off. Where is there a line that gets crossed when using deceptive techniques in terms of crossing a line of becoming too coercive? And to me, this is close. When you're representing, you have them sign a form that says, one, there's a waiver of liability. I don't understand that. But it also implies that it's admissible in court. And so you're confronted with this machine that gives 100% accurate, it's a truth-telling machine. And you're confronted with the fact that could be admissible in court. Why isn't that coercive? And so what choice do you have at that point to take the test or not to take the test?
But that's a thing. That's a part of this for me is a logical challenge. I don't understand how telling him before he takes a test that it's 100% effective is likely to coerce an involuntary confession out of it. Because if he knows, if he actually believed it was 100% effective, well, he would have said, no, I'm not going to take it. I'm stressed. I haven't slept. I haven't yet eaten. I don't want to. I mean, he obviously didn't believe it was 100% effective. He believed he could get by the test.
I don't know that that's true. You think about if somebody gets pulled over on the highway and they're carrying 59 pounds of marijuana, you have a lot of people, they say, can we search your car? And they're thinking, well, I want to be cooperative. And maybe they won't search my car if I'm cooperative. So they say, yeah, search it. Because don't you always wonder all those cases? Why do people allow a search of their car?
It is illogical. And I think in this, I mean, they gave him so many opportunities. You don't have to take this.
Pointing out what you said.
Yeah, to me, it's illogical. I still don't.
I'm not sure
follow
I'm
the logic.
following, because to me, it would be that he believes it's going to show, even if I'm nervous and stressed, that I'm still telling the truth. Because it's 100% effective and I didn't do it.
Yeah, well, that's what he
So it's
thinks.
right.
But he knows that he did do it. I mean, in the back of his mind, because again, once we get past this, remember after, let's jump past the
Well, let me
test.
challenge that as well. We have cases all across the country with false confessions. I mean, we've got cases built on some of that. People do confess even if they're not guilty.
But can they provide details of the crime that no one's told them before? Do they continue to deny some parts of the crime, but only confess to others? Because that's what happened here.
It's after the fact that we look and see if it's coercive.
I'm sorry, what?
It's after the fact.
What do you mean?
After the fact, I mean, this is all pre-confession. So it's after we look at the result.
Well, I think, yeah, you have to look at the totality of the circumstances. I think, I guess I'm not understanding your
I don't think
question.
that's not the case law. I mean, what this goes to is due process.
Right.
Whether you are getting an involuntary confession. So the voluntariness has nothing to do with whether or not the person actually did it. I mean, there's
Oh, right.
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 So the fact that he can provide details of the crime that the police didn't know, that's irrelevant because we're looking at, whether it's an involuntary statement that was coerced.
Right. And I part of this is I don't think I'm ever fully able to get my whole point out here, but after he took the test and they told him he failed, I mean, let's be honest, he continued to deny for a while, right? So he continued to resist and say, no, I didn't do it. They continued to persuade him using pretty traditional accepted police interrogation techniques, saying, look, man, come on, you need to come clean. It looked better for you if you told the truth. Come on, we don't think you're a monster. We think maybe just was like a little mistake, the usual. And finally he said, okay, fine, I'll confess. I did this, and this, but he still did not confess to everything. He only confessed to some things. He didn't confess to the worst things. And he also then, of course, provided details of the crime that were not fed to him. He pulled them out himself. So clearly, I think you can look at this and say, he volunteered that information. Why he volunteered it is, he thought it would assist him. It would be the right thing to do. Whatever, but he voluntarily confessed. And the police didn't do anything in this interview that is not really in the standard book of ordinary police interrogation procedure. And the CVSA thing, even if they did, exaggerate how effective it was, again, I mean, if you can hook a guy up to a plastic box that doesn't do anything and tell him it's a lie detector and that he failed, I don't see how overstating the effectiveness is worse than that. The case law is pretty substantial, saying that they can use this kind of subterfuge to induce somebody to tell the truth. I also want to point out that I don't think that the Court of Appeals here did any factual finding or reweighing the facts, anything like that. The facts are not really in dispute. What we're talking about here are the inferences and, most importantly, the legal conclusions to be drawn from those facts. And let's not forget that the Court of Appeals, or the District Court, drew two different legal conclusions from the same set of facts. I mean, initially, the District Court said, yeah, this is voluntary, not going to suppress it. And then with no additional fact finding or anything else, just the passage of time, the District Court comes back 18 months later, I think it was delayed because of COVID or something, and says, I think that the police deceived him on the CVSA thing, so I'm going to change my mind. So on the same set of facts, even the district court came to two different conclusions. And I think the Court of Appeals looked at that same set of facts and came to the correct legal conclusion. The Court of Appeals did not substitute its fact finding for the district court. I think that's wrong.
Let me ask about that because I was a little confused from the record. I read the transcript of the Jackson v. Deno hearing, and it ends kind of where they're jammed up at 5 o'clock and they had to move the expert from the defense up, and then they squeeze in the two detectives. Unclear to me whether they ever resumed that hearing because I didn't see anything in the record where they would have resumed the hearing, which gets to your point about what the additional facts that the district court may have had. You see what I'm getting at?
Yeah, I don't think there was.
Okay.
I don't think there was anything.
I didn't see anything either, but it just kind of dropped off the edge of the cliff rather than I'm taking this under advisement and I'll get back with you. You know.
I mean, ultimately, though, when you look, the district court did make its first conclusion and said that there was, on the same set of facts that this was voluntary. And then when it came back, I think it was 18 months later, the only thing that the district court really focused on was it changed its mind about the deceptive conduct of the police with the CVSA. And so that's what the focus was really at the Court of Appeals was about that.
But you don't know that's the only reason that he changed his mind.
Well, I mean, we have his ruling. I mean, that's pretty much what he says.
So you
says
don't know that's the only reason he changed his mind.
Well, I mean, I don't know if there's any reason that he didn't state. I mean, I just know what he stated on the record.
Right. And he said he thought about it. And whose job is it to decide the collective weight of the evidence?
In this instance, it would be the judge.
And how is it that we then can gauge as an appellate court whether or not he gauged the lack of sleep too heavily, or perhaps the lack of food too heavily or too lightly?
Well, partially that goes to what Justice Stiegel brought up earlier about, well, is it substantial competent evidence or not to support that? And the standard of review says that, I've got it here somewhere. Essentially, it is that while you defer to the factual findings below, the ultimate legal conclusion is de novo. So it is still up to this court to determine whether the district court drew the correct inferences and the correct legal conclusion from those facts.
Were there any findings that the district court made not supported by substantial competent evidence?
Well, I think the finding that the police were unduly, unconstitutionally coercive with the deception about the CVSA.
Is that a factual conclusion or a legal?
Well, I guess that's a legal conclusion. I mean, I don't think there's any real dispute about the facts. It's like I said, it's the inferences and conclusions drawn from those facts. That is the difference. And that's why, like I said, the district court itself came to two diametrically opposite legal conclusions off the same facts. The Court of Appeals unanimously concluded with the district court, or agreed with the district court's first conclusion.
But
If there's more, but you keep talking about the inferences, but if a piece of evidence, if you can draw two reasonable inferences from that, with substantial competent evidence review, we defer to the district courts, the inference that the district court drew from that evidence, as long as it's reasonable.
If it's reasonable, right? Yeah.
Right.
But I think that the Court of Appeals concluded that the district court's conclusions here, in the second decision, were not reasonable. And I would submit that that's the correct result.
Let me go back to that line that I asked your opposing counsel about, where they say the thinly veiled attempt, his nervousness was a thinly veiled attempt to offer an innocent explanation of any stress registered by the test. They draw an inference that's contrary to the inference of the district judge. Was that an unreasonable, did the judge draw an unreasonable inference? And how do we get there? How do we make that leap from his inference to theirs?
Well, I believe that is a reasonable inference. I think that probably every person who takes a lie detector or a similar test knows, and they're always going to be nervous, and they offer that up as a potential excuse. Hey, if it comes back and it looks bad, well, it's because I was really nervous. I think that's a logical inference, a reasonable inference to draw.
But that's not the one the district court drew.
Well, that's the one the district court drew initially. which is why it's so strange that the district court then just changed its mind with the passage of time. So I guess when you say, well, there's a couple different, legal or different reasonable inferences, one maybe is more reasonable than the other. When you have, 3 judges on the Court of Appeals and a district judge all agree, and then the district judge kind of changes his mind, I don't know. I don't know how you slice that cake. I mean, it's.
Well, doesn't somebody else have the burden of proof if that happens? If he decided it the other way?
What do you mean?
Well, if the district judge had made different inferences as to the effect, the collective effect of stress and the lack of sleep and the lack of food, you would not have to argue that the judge made the wrong inferences or gave it the wrong weight. That would be the other parties do.
Well, right. I mean, yeah, that's why we're here. I mean, that's the argument we made to the Court of Appeals is, and essentially at the Court of Appeals, no one was really arguing about anything but the CVSA, the deception, and which is kind of,
So how do we parse that? How can we possibly say the district judge gave too much weight or too little weight to things that are immeasurable, like stress or lack of sleep or lack of food? Isn't that why isn't that the point of giving the district judge the deference for his own mulling or thinking or views on what is important about demeanor and all of these things collectively?
Well, sure. If it was based on, testimony, but in this case it wasn't, it was just based on the video, which is part of the record, which you can see. Also, I don't think the district judge clearly stated that he was relying on that.
Does he have to?
I think he does if you're going to rely on it. But what he clearly stated was he didn't like the supposed deception with the CVSA.
Aren't we relying on it by giving it deference?
I'm sorry, I was trying to look at my notes. I asked that again.
Aren't we relying on it by giving it deference?
Well, yes, if you give deference to something, you are relying on it, yes. And what I'm suggesting to you is that the logical inference and the legal conclusions drawn from the facts is correct as the district court initially found and as the Court of Appeals unanimously found. I think the district court, where it went wrong, just as the Court of Appeals said, it went wrong on the CVSA. It diverged from the case law, which says police can use deception. For some reason, the district court decided it had a problem with the police telling the defendant it was 100% effective, and that wasn't entirely true. And that was where the district court diverged. I think the Court of Appeals correctly focused on that. That's what the focus below was. And that brings me back to the point I just bring this up in passing. It's interesting in the issue presented in the petition for review was that, quote, the Court of Appeals reached an incorrect result by reversing the district court's order suppressing Mr. Garrett's statement because the Court of Appeals held in essence that deceptive police tactics can never lead to a coerced confession. That was the issue that was presented, right? So, we're focusing on that, but then my opposing counsel tried to broaden it in the supplemental brief. And I'm not going to argue that maybe that's not fairly included in the overall question, but the focus has always been about the purported deceptive practices of the police. That's what the district court hung its hat on. That's what the Court of Appeals reversed on. If you look at the rest of the factors, you can, the length of the interrogation, which I think, somebody else already one of you has already mentioned was relatively short. The age, intellect, background of the accuser, he's 40 years old. He by all appearances, average intellect. There's nothing to indicate he was not of average intellect or had any kind of disability or anything like that. He was employed. He spoke English. He understood what was happening. So there's no evidence he was particularly vulnerable to any kind of persuasion or coercion because of his age or mental capabilities or language. With respect to ability to communicate with the outside world, there's no indication he was denied that. He never asked to do that, but there was no indication he was denied that. The police interrogation was very calm. I mean, again, you can watch the video. So, I mean, there was no combativeness, no yelling, nothing like that, and so on. And then, like I said, at the end, he still didn't fully confess. I mean, he still resisted the police to some extent. I think that in itself shows that his will was not overborne. He was not a broken man just confessing to whatever he could say to get the police to leave him alone. That was just not the case. And I see now that I am well past my time. So if there are no further questions, I will conclude and simply ask that you affirm the Court of Appeals.
Probably you reserve 3 minutes.
Are there any other further questions of the court?
What do you think the legal test is for coercion? Or what would you argue it to be? And I'll just, since you're thinking, what one test that at least has been bandied about and shows up in our case law at various places is that a coercive interrogation is one in which a court cannot be certain that it did not elicit a false confession. Do you think that's an appropriate test for coercion?
Say that one more time. I'm
That a
sorry.
coercive interview or interrogation is one in which a court looking at it, we can't be certain whether or not it didn't elicit a false confession. It's effectively, the courts are worried about the danger of false confessions. And that's what, and again, I'm not saying that's covers the waterfront of the case law, but it is a point that shows up often.
It is very difficult, I think, to form a single test of what is a coercive statement, especially as this court has stated here today that we do know that people give false confessions.
That seems, I would agree with you that it seems like collectively in our jurisprudence, this has not been an easy standard to articulate. But doesn't that seem to be kind of a problem in this area of the case law? Like, we are trying to ask this fundamental question, was the interview coercive? But we struggled to define what that means.
I think in this matter, the court has to look at the totality of the circumstances.
Sure, I agree, but that,
Rarely in, sorry. go
no,
ahead.
we're just having a conversation about this difficulty defining coerciveness, and can you think of a better definition than the one I provide, that a coercive interrogation is one which could elicit a false confession? That seems to me to be as close as we've gotten to a succinct definition.
I would agree with that, but what I would advocate to this court is that to not use that as a single bright line test. Because rarely in these interrogations that happen with law enforcement and a suspect, is there only one method of coercion or deception that's being utilized. And so I think what this court has to do is follow its precedent and look collectively at the totality of the circumstances, which includes coercion. And what we know in this particular case is that there was evidence that the district court Judge Johnson relied upon to find in this particular matter it was coercive because of the egregious nature of the simply deceptive tactics that they used. Seeing none, justices, I would ask the court to reverse the Court of Appeals decision in this matter and affirm the district court suppression of Mr. Garrett's involuntary statements post CVSA. Thank you.
Thank you to both counsel for your arguments this morning. The court will now take this appeal under advisement. By that, I mean that the court will now conference the case, after which a justice will be assigned to draft a decision. That draft decision will be reviewed by all the justices participating in the case, and conversation will continue until a final decision is reached. That decision will then be published on the kscourts.org website, and a news release will be issued announcing its release. Thank you, counsel. I will now call 125-552 in the matter of the wrongful conviction of Baumgarner.
May it please the court, counsel. Larry Michael of Kennedy, Berkeley and Salina, representing the appellant Damian Baumgarner. Your Honor, may I have 3 minutes for rebuttal?
3 minutes is granted.
Thank you, Your Honor. Unfortunately, over a number of years, our culture and our society figured out that a number of people were, for various reasons, being sent to prison or incarceration that had not committed the crime that they were convicted of. To attempt to provide some form of remedy for this wrong, the Kansas legislature in 2018 enacted the Kansas Wrongful Conviction Statute, which provides a remedy for people that can show that they were wrongfully convicted of a felony crime. In this case, Damian Baumgarner, I believe it's uncontroverted that he meets all the elements under the statute, except the one thing that the district court dismissed the case on was a finding that he had not been imprisoned because he was held in the Sumner County Jail instead of facilities operated by the Kansas Department of Corrections. So the issue in this case for you is, under the statute, what does the word imprisonment mean? And
Can you
ironically,
clarify for me, what was the duration of his entire confinement? That's just not called. Wasn't it less than a year? As I was told, I came up with 10 months, but am I wrong?
no, that's correct, Your Honor. What happened was the underlying sentence for unlawful possession of a firearm, he was sentenced to 60 days in jail. That also constituted a violation of his probation in another case that added on another 6 months.
Thank you. That's I just
You're
wanted
correct,
to
Your Honor.
verify that. Thank
But
you.
isn't the legal question here just whether he was in custody of the state as opposed to some other correctional?
Well, there's two aspects to that question, Your Honor. The first thing I would say is he was in some form of in custody of the state because he did receive a KDOC number, and he does have a KDOC record as a result. But more importantly, Your Honor, the statute does not specify who you need to be in the custody of. And in fact, the irony is this court has specifically and strongly addressed the issue of the interpretation of this word. In 2002 in State v. Huff, the court said there can be no doubt that confinement in a county jail constitutes imprisonment. Based on that language, there's absolutely no argument that what happened to Mr. Baumgarner constitutes imprisonment without this court reversing several of its prior holdings, not just State v. Huff, but also State v. Walbridge. And
Although it wouldn't require reversing those holdings, would it? Those cases didn't have to do with this particular act.
it didn't have to do with this specific statute, but if you're going to rewrite the definition of imprisonment,
Well, I agree with you that the definition is what's at issue here. And
Right.
certainly you have read from our case law authority that is supportive of your proposed definition. But of course, there's authority on the other side too, which I suppose is what we're here to argue about.
well,
So how would you respond to the state's argument that, look, those Supreme Court cases are well and good in their context, but we have the sentencing guideline statute, which clearly defines imprisonment as being, quote, in a facility operated by KDOC.
well, again, you have to look at the specific statutory scheme you're looking at. The statute that the state primarily relies on very specifically contains the definition, but it also says it's specifically limited to that statutory act. ASA 21-608 et al.
So we have two conflicting definitions, neither of which is directly on point. How do we decide between them?
Because which one makes more sense? First off, the one that I'm arguing complies with the vast majority of legal interpretation. Not only is this case, or I'm sorry, this court ruled that imprisonment in a county facility is imprisonment. But if you look at the definitions in the legal dictionaries that were attached to our brief, it's pretty much universal that imprisonment is generally defined as any type of confinement. In fact, in Huff, this court said imprisonment and confinement are one and the same and may be used interchangeably. So when you look at the statute, unless there is a specific variation from that definition, the rules of interpretation would suggest we ought to use the common meaning of words. And in the common meaning of the word imprisonment, we do not limit it to confinement in a state facility.
So your argument is that the plain language of this statute produces a result which is the result you're arguing for, that confinement in the jail qualifies as imprisonment.
Absolutely, Your Honor. If
You're not arguing for an ambiguity in the statute.
No, I don't believe it's ambiguous because I think that this court has made clear what the word means. If the legislature, when drafting the statute, had looked in a legal dictionary, they would have come to the conclusion that imprisonment would include being held in a county jail.
Just in terms of the facts, wanted to ask a clarifying question. My understanding of the record, but correct me if I'm wrong, is that it's clear, there's no dispute that your client was sentenced to probation with the statutory 60-day jail time as a condition of probation. And the statute states that those 60 days are to be served in the custody of community corrections. Is that what happened here?
Yes,
We all agree.
that's my understanding, Your Honor.
And we also know that the statutes make it clear that when an individual is in the custody of community corrections, they are not in the custody of the Secretary of Corrections.
That's correct, Your Honor.
So at least factually, we all can agree, we know what happened. He was given probation as a sentence. The statute provides that when you're given probation after a felony conviction, the court can order 60 days in jail as a quote condition of probation. And that's what happened.
Exactly. And Your Honor, also, I think what's important, two things I'd like to add on to what I said before. One is not only in the criminal context, but in the civil context, we have a common understanding of what imprisonment is. False imprisonment in a civil context very rarely involves somebody actually in prison. It's usually somebody being held in the trunk of a car, being held in a basement, being held against their will. We universally have an interpretation of what imprisonment means, and it is not limited to confinement in a federal facility, or I'm sorry, state facility. The other thing, Your Honor, Judge Stigl, that I would say is we also need to look at the purpose of the statute, which is why I started out the way I did. I think there's no argument here that Mr. Baumgarner was held in a cell for 8 months wrongfully. He had not committed a felony as a matter of law as determined by the Kansas Court of Appeals. And if he wouldn't have been convicted of that felony, he would not have spent 1 day, additional day anyway, in a cell. And we talk about a cell, but really we're talking about a cage. And I think that sometimes it's easy to remove ourselves from what the effect of that does to people. I have a close relative that when I was younger had to spend a year at Larned State Hospital. He's 86 years old, and I doubt that there's been a day of his life he hasn't thought at least once about that year that he was away from his family. He was confined. And
Ask you a question. I do notice, and I don't know whether this makes a difference to your argument, but since you're talking about the purpose of the statute, when you are looking at 5004G. And G is the part, we're not talking about any money at this point, okay? The damages are under E. But if the claimant is entitled to judgment, it is only then that he can get, or she, a certificate of innocence. Is there any other way besides this statute to get a certificate of innocence?
Not that I'm aware of, Your Honor. This
So
is
the
the-
fact that he, spent this time in jail, even if there were no damages at issue, he would be precluded from getting a certificate of innocence.
That's correct, Your Honor. Mr. Paulseth and I we have another case coming your way out of Sedgwick County where the district court in Sedgwick County awarded my client over $400,000 under this statute, and the state is appealing that decision. You may find I'm being disingenuous, but I'm not. That certificate of innocence was as important to my client as the money. He spent 8 years in prison. And so I guess the point I'm trying to make here is, I think for most people, the amount of time that you're held in that cell, that cage, being confined, you don't care where it's at. You don't care whether it's a state facility, a county facility, the state mental hospital, but you're confined away from your family. You're missing opportunities to spend with your kids.
Let me ask one other, just one other question.
Sure.
So what do we do? Let's say that a hypothetical that this happened, but the individual spent 6 months and 1 day in the custody of the KDOC. How would we interpret this statute, which gives damages by the year? Is there any precedent or anything for saying that it should be prorated or?
This issue came up to some extent in our Sedgwick County case, and Judge Comer in that case basically just prorated it. It's, when we talk about interest, post-judgment interest is 10% per year. Well, that doesn't mean you have to have the judgment a year before you're entitled to interest. Whatever amount of time you have gets prorated based on that rate. And
Is it your position also that that piggybacking the probation revocation that was based on the commission of the felony also comes under this umbrella? And if so, what can you explain to me the legal analysis in that?
But for the wrongful conviction, he would not have had to spend those 6 months. So the wrongful conviction resulted not only in a sentence in the underlying case, but it also caused a violation of another case, which resulted in further jail time.
Now,
So,
do you believe that the statute addresses that in any way, or is that something you want us to just, make new law, I guess?
well, I don't think you need to make new law, because I think that if you look at the statute, it doesn't directly say that the damages are limited solely to the crime for which the underlying sentence was imposed. It talks about time spent in jail. And I think the reality is a lot of people that would be possibly in this situation, you could have other cases. And, you could even go so far as to say, well, it's impacted by where you are on the sentencing grid. So there's a lot of things that impact the length of your sentence. And the legislature enacting this statute didn't put any limits on that.
Would you agree that those 8 months or 6 months additional were not time served on the wrongful conviction? Would you at least agree with that?
I'm not trying to be disingenuous, Your Honor, but I honestly would take issue with that, because but for
Right,
the wrongful conviction.
I understand your but-for argument, and it makes sense. You're just saying, look, this wrongful conviction is what triggered the revocation in the prior case. But it would seem to me we could at least agree that the time served on the underlying prior case is not time served pursuit for the wrongful conviction. I mean, this is legally speaking, it's not.
Right. And if the court were to rule that way, then Mr. Baumgarner would still be entitled to prorated 2 months under that crime plus
And
a
the
certificate of innocence.
innocence.
Can I ask you to clarify? I think maybe Justice Stiegel had asked you, and you sounded to me like you were conceding as a factual matter that Mr. Baumgartner was not in the custody of the state. But at the opening, I thought you mentioned that there was evidence suggesting, even under your opposing counsel's interpretation of the statute, that there's at least a fact question as to whether DOC had custody because he was assigned a number. And that could be significant because I understand this was an issue decided on a motion to dismiss.
Correct, Your Honor. The record in this case was confusing, and my apologies. I've never practiced criminal law per se. So I'm not as familiar with a lot of the attorneys that appear before you on some of these niceties about sentencing and such. But when I initially was contacted by Mr. Baumgartner, I was under the mistaken understanding that he actually had been in state custody because I looked him up and he had the KDOC number and there was a reference to that conviction. It was only then after Mr. Qualseth got involved and clarified that no, he had actually been held in the Sumner County Jail. So that's a long answer to your question, but I suppose, yes, that gets down to what does it mean to be in custody? I mean, he was under the jurisdiction, as I understand it, of the Kansas Department of Corrections. If he would have violated his probation on the underlying case, it's my understanding he very easily could have been back in a state facility. So I think you make a good point about how do you define exactly what custody means. But I don't think we even have to get there, because I think the mere fact that he was confined satisfies the purpose and intent of the statute.
Can I just ask a couple procedural questions real quick? You filed your petition and then the state filed a motion to dismiss, correct? And then there were additional affidavits attached to the pleadings in response to the motion to dismiss. So the legal standard that the district court applied would have been a summary judgment standard. Is that correct?
You're correct about the affidavits, but it was my understanding the judge applied a motion to dismiss standard, but I should
That's
caveat.
Possible. I think that's the same. How is it possible if the district court is focused on what jail your client's in? That's a fact statement.
Correct.
And even if you guys stipulate to the facts, we're already in fact world. I mean, that doesn't seem like an appropriate application of motion to me.
I guess the reason I considered a motion to dismiss is there was no, we weren't allowed to do any discovery. The only additional information was the affidavit.
Right. And I mean, it's pretty standard case, a lot of talk about when there are additional facts, affidavits that come in after a motion to dismiss is filed, we treat it like a motion for summary judgment, even though, yes, it's a very preliminary one that happens before discovery, but that's the legal standard that we're under here, right? We're reviewing this district court decision as if it was a motion decided on a motion for summary judgment.
The problem I have with that is we really didn't do discovery. I think the only.
Well, I guess that leads to my last follow-up, which is if we rule in your favor, and really the only issue before us is the proper statutory interpretation of the word imprisonment. If we rule in your favor, your client wouldn't prevail in this case. That would just send it back down for litigation on all the other factors in the statute, correct?
That's correct, Your Honor. The statute contemplates a bench trial.
But there are the state has other defenses, obviously,
Oh.
that they're not before us. They have not yet been joined because the district court essentially cut this case off at the knees by ruling that your client could not qualify under the imprisonment factor.
That's absolutely right, Your Honor. And I can tell you, and you'll be seeing over the next few months, the AG's office has been very clever about trying to come up with defenses to this statute. So I think we have 4 cases in total right now in the pipeline that you'll get to decide. So there's other aspects of this statute clearly that the state will argue as well. But I guess my fallback to your argument though about whether it's summary judgment or motion to dismiss, Your Honor, in my experience, typically a judge will say in their decision whether they're going to treat it as a motion for summary judgment or they're treating it as a motion to dismiss. Nowhere in the judge's order do I recall him ever referencing or saying he's going to treat this as a motion for summary judgment.
Well, okay, so in your petition, you pled that your client was imprisoned.
Correct.
And so if we were on motion to dismiss standard, we have to take all well-pled allegations as true.
Correct.
And so on that standard, you would prevail because you pled that he was imprisoned, right?
Correct.
To what extent was the court permitted to take into account, for example, the journal entry of sentencing? Was that attached to your petition, or is that an additional fact finding?
No, that was an additional fact finding, as I recall. So
that has to be summary judgment, right?
well,
or is your argument that the district court improperly considered facts when it should have just denied the motion to dismiss, proceeded to discovery, and then we would have the exact same argument?
well, again, I guess I'd say 2 things to that. The first off is I think it's a distinction without a meaning because this is clearly a legal issue. So I think the standard of review is going to be the same regardless of whether it was an SJ or a motion to dismiss. However, I guess I would still resist a little bit conceding that it was a motion for summary judgment because, as I said earlier, my experience, courts will usually say which direction they're going to go. And I don't think a district court is required to take some additional evidence to clarify a fact issue and say it's going to treat it as a motion for summary judgment. So I, with all due respect, I'm understand where you're coming from, but I just don't feel like I can go so far as to concede that under this specific situation.
Questions?
Thank you.
Chief Justice, may it please the court. My name is Curtis Wired and I represent the state of Kansas. Your Honors, I want to focus on the discrete legal issue that's before this court today, and that's whether the district court correctly held that the term imprisoned as used in the wrongful conviction statute includes time spent in the county jail. We believe that the text of the statute demonstrates that it does not include time in the county jail. It says,
Is that the right question? Where the defendant physically was? Or is the question in what entity's custody was the defendant? And the reason I ask this, it comes right off the top. This is the first thing that kind of came to mind when I saw this is just knowing as a general practice that sometimes the Department of Corrections will house inmates in county facilities to solve various logistical overcrowding issues or just logistical transport issues. I mean, is your position really that someone who's serving a sentence with the Department of Corrections who just happens to be housed in a county jail doesn't qualify? I mean, that's an ancillary question. I get it, but that was the way you framed your very opening statement raises that question again.
yeah, I don't know about those specific, are those particular exceptions where they've got.
Well, that's what you're
overcrowding
arguing.
issues and they
You're
move-
saying that if you're in the county jail, you can't recover.
Well,
And
here-
I'm asking about a hypothetical where someone is in the county, is clearly serving a prison sentence, but just happens to be housed in a county jail under the auspices of a contractual arrangement or what have you between DOC and a county jail.
I mean, I think that would be a very different analysis if you were actually assigned a KDOC number, which Mr. Baumgarner evidently was here, but then you were actually supposed to be shipped to a prison.
Well,
That's very different than.
well, I guess I'm just trying to figure out if you really mean what you say. When you say, if you are physically in the county jail, you cannot recover. Or are you making a slightly narrower argument?
No, I would say I'm making a narrow argument that the use of the term felony crime as used by the legislature connected with subsequently imprisoned indicates that the legislature was focused on those individuals who would most likely end up in the custody of the Secretary of Corrections.
That's
but
your
where-
argument. Sorry, Chief.
Well, where is the word custody? Where is the requirement that there has to be some proof of whose custody this person was in? I just don't see that anywhere in because you said we can look at the plain language of the statute. And I don't see custody or a question of custody anywhere in the statute.
Yes, Your Honor, that it's nowhere directly stated in the statute.
So we do have to look outside the bounds of the statute. Contrary to what you.
Well, I think if you look at felony crime connected with subsequent imprisonment necessarily implies custody with somebody. And in this case, a felony crime means most likely somebody who's put in the custody of the Secretary of Corrections.
But the legislature has directed that for these felony crimes, they can be imprisoned if we would use the broad common definition that's been presented to us. And that imprisonment can be for punishment of this felony crime, 60 days in a county jail. So why isn't that enough? That the legislature has spoken that this is a felony, a consequence of a felony conviction.
It is. I would say that, I'm sorry, could you rephrase your question?
The sentencing statutes set up for for felonies that some of them will be probation and that a part of that probation can be 60 days in the county jail. So the legislature has defined this as a form of the punishment for a felony. And it involves, if we apply a common Black's Law Dictionary of imprisonment, it involves imprisonment in a county jail.
Yes, sir. Thank you very much.
Why is that enough? Not enough.
So I think that there are several answers to that, but if we're talking about the plain ordinary definition of imprisonment, I don't know if the dictionary definitions quite get us there. My friend on the other side talks about the very broad definitions of any restraint on liberty. However, this court's already held in State v. Scherzer that house arrest does not qualify as imprisonment. So, and I believe that the court referenced some old attorney general opinions that use that definition of imprisonment. So I don't think that broad dictionary definitions can get us quite there.
But back to my question, I'm focused on what the legislature allowed here.
Right.
And that was confinement. I mean, jail is not house arrest. Jail is confinement in a prison. It just not a prison that's under the custody of DOC. It's under a county corrections. What's the difference? I mean, if the legislature deemed that to be an appropriate place to put a person convicted of a felony.
Right, and this narrow carve out comes from State v. Walbridge, the court's holding here. The legislature changed the statutory language to provide for the specific sentence that Mr. Baumgarner received.
And isn't it important that in that legislative enactment, which is contained in 21-6603G, the legislature chose to describe those 60 days as, quote, imprisonment? Isn't that important here?
Are you talking about in 21-6604, the authorized disposition?
No, I'm talking about the definition of probation, which is the specific, I think, the specific subsection under which this defendant was sentenced. This is the 60 days in county jail. And the statute says that probation is this procedure where a defendant is released by the court without imprisonment, except as provided in felony cases. And then it goes on to say that the court may, as a condition of the probation, orders up to 60 days in county jail. And if you read those two sentences together, those 60 days in county jail are being described as imprisonment.
I have here that it says confinement in county jail not to exceed 60 days was the statutory fix. I think confinement just as in the authorized disposition statute in A1 and A3, where
And the sentence before that describes that confinement as, it says, I mean, it's defining it in the negative because it's saying without imprisonment, except as provided in felony cases.
sure, I take your meaning, and I think the lesson you can draw from this is that the statutes are all over the place. Huff made that point, that there are a number of statutes where the legislature admittedly has mixed confinement, imprisonment together, so it is difficult.
Does that make it ambiguous in this statute?
I think it can make it ambiguous in this statute, and this court could turn to canons of construction to reach a definition.
If we were to do that, what's your best argument for the position the state's taken? If we were to move on to canons of construction?
I would start with the legislative history. I think if you look at the legislative history, the proponents of this legislation, the people who drafted it and testified in its favor, were clearly concerned about individuals who had spent years and years, in many cases decades, in prison and then were subsequently exonerated. They weren't concerned about an individual who had spent 60 days in the county jail.
Are you exonerated without a certificate of innocence?
I know you asked this of opposing counsel. I'm not entirely certain if there's another way to receive a certificate of innocence in the statute. I'm assuming there isn't, but I can't say for certain.
Is this a statutory remedy? What the scope of this remedy? It can a claimant bring an action against a municipality? Specifically a county?
I have to apologize, Your Honor. I don't know the answer to that question off the top of my head. Before we move off of Huff, though, I know we started talking about ambiguity. I do want to point out there, though, that the statute at issue in Huff said the language at issue was separate sentences of imprisonment for different crimes. And this court focused on the phrase different crimes and said that it clearly includes both felonies and misdemeanors. And I think this is the key statutory language that distinguishes Huff from this case, where the legislature chose to limit recovery to those individuals who were convicted of a felony and subsequently imprisoned. So I don't think Huff gets us over the finish line. I don't think the dictionary definitions get us over the line. So it's perfectly reasonable, even before this court were to declare that the language is ambiguous, to look elsewhere in statutes. And we can look in the Kansas Sentencing Guidelines Act. Admittedly, it does state by its own terms that it's limited to its act. But if we're left with a term that lacks a definition, it's perfectly appropriate for this court to look at other statutes in par materia with this current statute. And their imprisonment is clearly limited to time spent in a KDOC facility.
When you're talking about in peri materia, so we can flip flop from civil to the criminal code? You're saying we have to look at the statutes in peri materia from jumping from the civil code to the criminal code?
Your Honor, I believe the case law says that if the statutes concern the same subject matter, then the court can compare the two and use terms.
And you're saying that these do. Well,
Yes.
one is exoneration, as you said. And then payment and the certificate. The other one is defining it in what context?
What's in sentencing, but we're dealing with an individual whose sentence was later overturned. These civil statutes come later in time. However, they're necessarily going to interact in every one of these cases where someone is sentenced and then we have the civil case come up. So yes, I think they concern the same subject matter.
You find authority anywhere, not even, I don't recall anything in Kansas. I don't trust my memory though, because but I don't recall any in Kansas. And so I'm curious if there's any authority that discusses application of in peri materia when you have a statute that you're looking to that excludes, that says, no, this is a statute that only applies in this limited area.
I wasn't able to find a Kansas case, Your Honor. I don't have my brief with me. I did find an out-of-state case, and I believe that the term that they were trying to define was marital status, but I don't recall if that term was supposed to be limited to a particular statutory scheme. So I am not aware of any. The other point I'd like to make, assuming this court does find that the language is ambiguous, which it very well could, is that in MM, this court already said that it will not read this statute broadly in favor of a claimant, that this is not a remedial statute. Rather, this was not in my brief, but I'd like to add that since this statute represents a waiver, a narrow waiver of the state's sovereign immunity, the court should also narrowly construe the term imprisoned, given this particular circumstance. And I have some US Supreme Court case law that says waivers of immunity must be construed strictly in favor of the sovereign and not enlarged beyond what the language requires. So I think if you look at the legislative history, you look at you take into account the fact that this involves a waiver of sovereign immunity. I think the court could find that this term is limited to time spent in the custody of the Secretary of Corrections.
Along those lines, is it possible we're going about this the wrong way by asking the big picture? We look at the statute and then we say, well, what does this word mean in the statute? Another alternative way of approaching the problem is to simply ask, was this defendant sentenced to imprisonment? Much narrower form of the same kind of question.
I suppose you could ask that question.
If we ask that question, how would you answer that question?
I would say that no, he wasn't sentenced to imprisonment. He received an underlying 10-month prison sentence. However, he never went to prison. He was placed in the county jail for 60 days
Right. But
as a condition of probation.
That's what happened, but what his sentence was he was sentenced to probation with a 60-day jail time as a condition of probation under 6603G. Would you agree with that as a sort of clinically accurate description of the sentence?
Yes, that's what his journal entry of judgment states.
And we could just ask, well, what is that imprisonment?
I suppose you could. I did want to ask a follow-up. I know Justice Wall had asked about whether the KDOC had actually taken custody. I believe below there was an affidavit that was added to the record of an individual from KDOC that confirmed that that Mr. Baumgarner was never placed in their custody. Unless there are any further questions of the court, I would ask that this court affirm the district court.
Yes, you do. Show you reserve 3 minutes.
All
We don't
right.
usually penalize you when we ask the questions that cause you to leave,
Okay.
to go over time.
All right. What I'd like to do is answer a couple of questions that were asked of my friend from the AG's office. Justice Wall, your question about whether an action can be brought against the county. Under this statutory scheme, the only defendant is the state of Kansas. And in fact, the caption isn't even supposed to be against the state of Kansas, it's supposed to be in the wrongful conviction of Damian Baumgarner. So that's not an available remedy to sue the county under this act.
But does that inform our interpretation of the statute in terms of maybe does that help us at all?
Well, yeah, I think it helps.
What imprisonment means?
Well, I think it does, because if you could go after the county, that would mean there'd be a separate remedy or a separate procedure for that situation. Obviously, the statute applies whichever way you decide, it applies to all governmental entities that are involved in incarcerating individuals. And Justice Standridge, I wanted to follow up on your question about exoneration. First off, it is my understanding from my research that this statute is the first time that I can find any reference to a certificate of innocence. And I do think that was one of the objectives of this statutory scheme, was because even if you're released, you still have that on your record, and it can impact your job and educational opportunities. So I think, and that also, I think it's important to clarify, when you talk about exoneration, I hear that word used a lot. But the reality is, in our criminal justice system, it's very rare for somebody to truly be exonerated. Many times when cases are dismissed against people, the prosecutor will just say, well, they've served enough time. We're not going to use our resources to re-prosecute this person, or a witness died, so we're not going to re-prosecute this. So even if the case is dismissed, the defendant is not exonerated. They just are someone who no longer has the threat of trial hanging over their head. The final thing I wanted to say is the legislative history. I would not give much weight to that, because obviously the big glaring situation that people think about are the people like my prior client that was in prison for 8 years. But that does not mean that the legislature meant to so limit it. If they had intended to limit it to a certain period of time, they would have said that, but they didn't. So I think any amount of imprisonment, you're entitled to some remedy, whether it be the certificate of innocence or a pro rata share of the monetary damages. Thank you for your time and questions, and we would respectfully request that you reverse the decision of the Sumner County District Court. Thank you.
Thank you to both counsel for your arguments. Court will now take this appeal under advisement. We will be in recess for approximately 15 minutes till about 10:50.